That's Bonnie. Faye Dunaway. That's Clyde. Warren Beatty.
Hello! If that Bonnie and Clyde introduction didn't give it to you, I will. Today we're coming at you with accomplice evidence under the Indian Evidence Act. The two main sections under the Indian Evidence Act, which are always identified with accomplice evidence, is Section 133 and Section 114 Clause B of the Indian Evidence Act. Let's just see what these sections say. Section 133 of the Indian Evidence Act provides that an accomplice shall be a competent witness against an accused person, and conviction is not illegal merely because it is based upon the uncorroborated testimony of an accomplice. And Section 114 Clause B provides that an accomplice is unworthy of credit unless he is corroborated in material particulars. Many people read these two sections and jump to the conclusion that they are in contradiction to each other. Today we will look into these sections, their relationship to each other, and everything you need to know about accomplice evidence. But before that, let's just start with the basics. Let's move on to the meaning of the word accomplice. Accomplice can be any person who has participated in the crime with the accused. The accomplice may have been an accessory before the crime, or may have been present at the time of the crime, or may have even helped after the crime. For example, to obliterate evidence or to clean up the place or something in the similar manner. In all these cases, the person is charged by the prosecution as a co-accused. Still didn't get it who can be an accomplice? Look at this one and you surely will.
I can't sell the Taj Mahal. You can किराए पे ले it.
I own the Taj Mahal. पागल है क्या? पागल है क्या? पागल है क्या?
So you get it now. Bubbly is Bunty's accomplice, Bonnie is Clyde's accomplice, so on and so forth. Now let's get back to the study. But how does this co-accused turn into a government approver and give evidence against the main accused? Let's see. How and why is the co-accused turned to government approver? Sometimes when the crime is too big or too heinous and there is a lack of evidence against the main accused, the prosecution makes the co-accused a government approver and he is asked to give testimony against the accused. Sure, it's unfair in a way given that the accomplice will get lesser punishment, or he will not get a punishment, he will get away with it and he does not get his comeuppance. But mostly the prosecution thinks that at least this way the main accused will not get scot-free, whoever had the bigger role to play in the crime. Secondly, it is also important to know that the co-accused cannot be given an oath under the Oaths Act. Hence, if you want to make the co-accused a government witness, it is essential that you give the co-accused a pardon under Section 306 of the Code of Criminal Procedure and then turn him into the prosecution witness, because as long as he is a co-accused, he cannot give testimony. You want him to give testimony? Turn him into a government approver and give him pardon first. So far so good. Let's move on to the main topic, which is the relationship between Section 133 and Section 114 Clause B. Now, we've already read the Section 133 and 114 Clause B in the beginning of this video. So, you understand that Section 133 provides a simple declaration that the evidence of the approver or the accomplice will be legitimate and he will be a competent witness. And in fact, it further provides that conviction will not be illegal just because it is based on uncorroborated testimony of the accomplice. Uncorroborated means that there was an independent witness or independent evidence to corroborate what the approver said. And in that case also, his testimony will be legal and the conviction will also be legal. However, as we've already read, Section 114B provides that accomplice is unworthy of credit and unless he is corroborated. So which one is correct? Uncorroborated testimony is good under Section 133 and 114 Clause B says that accomplice evidence is not good unless corroborated. What should we make out of this? It is important to understand that Section 114 Clause B is not an independent clause. It has to be read in consonance with the main clause, which is Section 114. After which, of course, the Clause B is given as an illustration. So we must read Section 114 first before we read the illustration, which is Clause B. And Section 114 provides that the court may presume the existence of any fact which it thinks is likely to have happened, regard being to the common course of natural events, human conduct, public-private business in relation to the facts of the particular case. And then it goes on to give the illustration B regarding the accomplice. Hence, it is important to understand that the court may presume certain things in the natural course of events given the facts and circumstances of each case. And if certain case has such facts and circumstance that it seems that the accomplice is trying to evade the sentence or become a government approver so that he can get away with it and he does not have to be punished, or he is acting smart and he had a bigger role to play in the crime and now he is just trying to get a lesser sentence by becoming a government approver. In all these cases, if the court feels that the accomplice is trying to swindle the justice mechanism of the country, then the court may presume that the accomplice evidence is unworthy of credit unless corroborated by independent evidence, which is given by Section 114 Clause B, that it should be corroborated by evidence. This is not a rule of law which has to be followed in every case like a straitjacket formula, but depends on the facts of each case, as the main Section 114 provides, to which illustration B is an appendix. In conclusion, if the court feels that the accomplice is trying to swindle the court may take a presumption under Section 114 Clause B as per the facts and circumstance of that case. However, if the court believes that the accomplice is being honest and trustworthy and his testimony can be used, the court may go on to convict the accused on uncorroborated testimony of the accomplice. And as per Section 133, that conviction will be legal and valid. Furthermore, it is important to remember that even if the presumption is taken under Section 114 Clause B, the presumption is a rebuttable presumption of law, as the words "the court may presume" have been used. Hence, the presumption, even if taken, can be rebutted by evidence. But the main point being that Section 133 and Section 114 Clause B are in harmony to each other and are not contradictory, as most people believe. If the accomplice evidence is such that the court believes he is being true, go ahead, convict the accused, and it will be perfectly legal under Section 133. However, if the court feels that the accomplice is trying to swindle the justice mechanism, then the court may take a presumption against the accomplice and say that we need corroboration for this accomplice evidence as has been given under Section 114 Clause B. So I hope you understand that it depends upon the facts of each case, and these two sections are not loggerheads with each other. The court does not have to take a presumption of 114 Clause B in every case. However, it is true that even though the presumption is not a straitjacket formula, not a rule of law, but in most cases, the court, as a rule of prudence instead of a rule of law, does try to get independent evidence of whatever the accomplice is saying. They try to corroborate it, as has been held in the case of Dagru versus State of Maharashtra, which is a 1977 Supreme Court judgment, and also held in an older case of Bhaboni Sahu versus the King, which is a Privy Council decision of 1949. Now, this is all the concept you need to understand accomplice evidence at a very fundamental level. If you guys want me to do a detailed case on accomplice evidence, leave me a comment and we will get to it next week. Till then, adios.